Hey guys, welcome back to my channel. Welcome back to Real Talk Bougie, guys. It is not your imagination. I totally started and stopped the last live stream. I don't know how I did it, but it all happened in about 8 seconds. So I'm not sure what happened. All I knew is I was live, and then I think I obviously had to click end stream, and that was on a mistake. But whatever, things happen. Your girl ain't perfect, okay? Today is a Tuesday that feels like a Monday. So, okay. Smash the like button. Smash something, okay? Just don't click on end live, okay? Okay. I don't know who's here first the last time, but my God, everybody's a gangster. If you're back, if you came back for the 2 times, baby, you are a gangster. Happy Tuesday that feels like a Monday, guys. Okay, guys, I have a very important question for y'all. I have a very important question. Okay, so this weekend, there were shenanigans in Orange County, Florida. Sarah Boone's new lawyer was filing motion after motion after motion after motion. And they had court today. They had court at 9 o'clock and we missed it. Do you guys, I'm sure, like, y'all, I don't want to hear one on board. I can't stand Sonya, any of that. If you guys want to finish up the call from yesterday, we can do that right now, or we can do that a little bit later. Or do you want to watch court that just happened a couple of hours ago and see Sarah get her ass served? She sat down in the court. I literally just started watching it. That's probably how I disconnected you guys. Because I saw her smiling like she was getting ready to get over on something, and from the looks of it, I don't think she did. Um, you guys wanna watch court? Can someone drop the membership link? Period. Babe, of course, I'll do it. Thank you so much for even asking. I appreciate the support. Um, you guys are so sweet. Um Okay, and I will be back. Sis got all her rest this weekend. By the time we finish this up, it'll probably be time to go pick up Boo Boo from school. And then after I get Boo Boo from school, oh, I don't even want to think about it. I don't want to think about what I got to do after that. And then on top of that, then on top of the what I have to do, I don't. Y'all, let me be quiet. Let me not complain. Invite viewers to join the channel. Okay. Boone has a lawyer. She does. Yes, check the community posts. I have updated you guys on that. We got that far. There was a motion that was posted yesterday, but I was going to go live on it and I didn't bother cuz I figured we would just talk about it today. And something told me as I was a little distracted setting up this live. Something told me to check the docket, and they had scheduled court for today. Hold on, let me show you guys. Uh Hold on. Uh they scheduled court. I don't know when. So I guess this was e-filed on the 30th. I didn't see that. It's only motion of hearing. So it was filed on the 30th. The 30th was what? The 30th was Friday. So I guess they knew about court on Friday. So basically, September 3rd, 9 o'clock, defense motion. Hold on. Uh They did file the statement of particulars. I saw that yesterday. You guys can see this? Okay, good. Let me make it a little bigger. Um, this was the 30th was Friday, right? Judge Kranick was like, "What?" Okay, so Friday, Homie drops the notice of filing, notice of appearance. Notice of appearance, we know this, we've seen this plenty of times. Notice of appearance is new lawyer in town, right? Um, so he filed a motion to continue. He filed a motion of appearance. The notice of filing, I'm not sure what that was. What was that? Following digital evidence is available for copy. The circuit court, assistant state attorney. So they are sending, I guess they were just documenting that they were sending over to the new lawyer, notice of appearance. Which one is that? I guess it was filed twice. James Owens, we'd already seen that. Notice of appearance. Is this the same thing? James Owens enters his appearance as counsel on behalf of defendant. Notice is hereby given that James Owens hereby enters his appearance as counsel on behalf of Sarah Boone, and this is a certificate of service attached to it. So that's what the second one is. Notice of hearing, that's what we're into right now. Petition or motion for attorney's fees. Did he enter that? That's back with Winston Hobson, one of her previous attorneys who's still trying to get paid from the JAC. Notice of particulars, saw that over the weekend. Notice of particulars, motion for additional discovery. What is that? So they're going to listen to all these motions today. And he's asking for continuance. So he's asking for additional discovery on showing of materiality. The court may require such other discovery parties as I wonder if Judge Kranick is going to let him have it. I haven't seen it at all. The defense is requesting the office of the state attorney provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular, the policy in place at the time of the interrogation of defendant. He needs to stop. He really does. Like, you're so late, sir. Additional discovery, forensic. They want the forensic psychologist, but JAC is only paying but so much. Sarah walked in the court like she really had something. Ooh, here's the minutes already posted. Should I ruin it and read the minutes that are already posted or what? Trial management conference on the 20th. So he canceled the hearing on the 24th. He scheduled for the 26th for trial management, and trial is still scheduled for October 7. So a little bit of spoiler alert. Defense abandons motions previously filed pro se by defendant. Defendant's pro se motions for cost is denied as moot. Defense counsel to adopt motions as stated on the record, state shall file response no later than 9/10, which is a week from today. Denied as stated on record, state objects to continuance. Case to remain as previously set. Attorney may appear virtually for any hearing that is set. Parties to coordinate hearing and motion. So he's already trying to get privileges to be on um, Zoom or whatever. I hope Sarah's not sorely disappointed when Sir is not showing up for, in person, and she's ridiculous at this point. But anyway, she has a lawyer, good for her. She needs one, and she'll have someone to blame. Um she'll have someone to blame. Anyway, okay. So do we want to watch the court proceeding and then we'll come back with the rest of Nesto's reaction? I want to see the new quick attorney in action. Okay, the new quack attorney in action. Okay, let's do that right now since it's lunch and it takes us a minute. Sunshine, thank you, boo, for supporting. I appreciate you, babe. Thank you, thank you, thank you for boom supporting. Okay. All right, let's do it. Okay. So we got a quick catch up on the screen. We're looking at the docket. All right, let me pull this up. Hold on. I had it on Law and Crime. All right. Baby. And Law and Crime has it on for about an hour, but what it looks like is that it took a minute for court to start. And okay, let's get into it. Let me move this. I was surprised when court popped up on girl. I didn't even see it. I was busy over there in La La Land in the mommy sector this morning and did not even see it. I'm mad, but that's okay. It is okay. We got chin up, Sarah. Chin up, Buttercup. Okay. All right, let's get into it. Sarah is her regular salty and smug self. So let's see what Boo Boo is bringing to the table. Law and Crime got hip and put their little logo off to the other side. Now I gotta go. It's like, come on now, Law and Crime. Me, okay. Okay, Law and Crime. All right.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning, pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand, Madam Clerk's gonna go ahead and swear you in.
Do you solemnly swear or affirm that the testimony
I had to get in at least one drunk chick, which I know, Big Ange.
you're about to give shall be the truth, the whole
Look at her smiling all smugly. Is that going unnoticed that Sarah is looking very much like the cat who ate the canary? As she now has a new lawyer that she obtained for herself? Is she giving very much like, haha, I don't have to be pro se no more. Okay. Girl, you better not play. Look how she's looking. Oh, she thinks she's getting something. She thinks she's going somewhere. Okay? Look at her, bitch. Sis, I don't think it's going to go how you think you want it to go, boo boo, but I guess we'll give it a try. We shall give it a try, boo. Look at her. Look how smug she is. Baby. If I were JAC, I wouldn't pay him anything because he didn't come through the Georgia Department of Corrections or the Georgia Public Attorneys, Public Defenders. He shouldn't be qualified for a dime. Okay? He should not get a dime. He responded to her advertisement, which was basically no pay. Look at her. She's so happy with her bad self.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning, pleasure. Ms. Boone, good morning. Could you please
Yes,
state
girl, I
your,
couldn't spit it out.
raise your
I
right
could
hand, Madam Clerk's
not.
gonna go ahead
It
and
was
swear you in.
hard for me to
do you
say.
solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in a court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense that was filed on 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or llast night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I post them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the
Morning, sir.
hearing.
Thank you. The only thing I saw in the court file, Counselor, when I was prepping last night was the motion for statement of particulars, the columns number 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
So luckily, I didn't know they were going to be going through all of this, but I guess they do need to coordinate what they're going to discuss during this hearing. And clearly, we looked at the docket before court started. So they probably are going to get through this rather quickly because I think there's only like 30 minutes left in this and they're just now getting started. So if you're just now coming in, slide the bar back. We kind of went through and clicked on everything that they're talking about right now. But they're going to obviously get in depth and the judge will be giving their rulings. And Harmon, I think, is saying hi to everybody, right? Yes. Guys, welcome. Today is a Tuesday, but it feels like Monday. Okay. Welcome. We are going to finish up the Ernesto call. We started yesterday. Our good friend Joey from the comments came through to talk to us yesterday. So we had to stop and talk and get our heads together on what we were all thinking about everything. And we had a lovely chat yesterday afternoon, but we will finish up that call. Don't even worry about it. Don't worry, y'all pretty little heads over that. Okay. All the beautiful ladies of Bougie Gang, we are going to handle that business. Trust me. We will get it done on today. I promise. Okay. We're just going to do this little court situation. And as soon as we're done, I might just hang up and call y'all right back. Okay. So let's get through this. Because this tea was going on as I was live over in the mommy sector. I didn't even know what was going on.
Well, was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why, the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other three aren't.
This is what it's saying,
They were all filed yesterday, 19.
no one has mentioned certain things.
I agree with you. I mean, I'm not an attorney. However, I would imagine because everything has to be like subtitle explained. It's like if you've got experienced people or even people like just whether it's an experienced lawyer or not, when you have attorneys, you can govern yourself one way. With a pro se, it's almost like you have to, it's like when you're watching the testimony right now with Lil Woody, right? Woody is, I don't know if he has a true learning disability or whatever the case might be, but he has expressed, and the judge is very aware that he expresses he has a limited understanding. So when they ask him a question, they almost have to, sometimes it's 2 and 3 different rephrasings of a question because his ability to understand or be able to really comprehend the question, you don't know whether he's joking or not, whether he's playing with the people or not. So they have to come up with sometimes 2, 3, 4 different ways on how to ask him a question because he may not understand. And if you use like a euphemism, he doesn't get it. So I would almost imagine with a pro se who doesn't know the law, there's a lot of time there that you have to do some further explaining, right? So I can only imagine. I mean, for us out here on the outside, it's like, well, damn. Okay. I'm gonna break in limitedly. We'll talk when this is over, but we have about 30 minutes. Let's listen and see what's going on here.
Auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report that they were sent to all persons on service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Berklin 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berklin. I believe he has The autopsy, we cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already.
Yo, that's what I was going to say. Didn't they give her 2 boxes of evidence? Didn't they spend time with Prison Break investigations, having Prison Break digitize everything? If you have a lawyer now and the lawyer is taking over the case, why have you not at least gave him the 2 banker boxes or 2 secure lock sacks, the sacks that you were provided by Captain D. Giovanni? Why is this so hard? If this dude from damn up north in Florida has been watching, if I know about evidence, if I know about the 3 USBs, if I know about the evidence that are in the secure property bag, why doesn't he? Sir, have you been, yo, why doesn't he know? We know where the damn evidence is. It's up under Sarah's bed. Sarah got 2 boxes and D. Giovanni gave her 2 lock bags so she could keep her stuff and they could be compliant with the fire code. And she has everything digitized. And I'm sure Prison Break Investigations probably retained a copy. Ma'am, sir, why are you guys once again wasting the court's time asking for stuff that you already have been given? Can you tell us that?
When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and the crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
But if he wants to come back to my office, we can do it this morning / this afternoon.
Is your
Office in the building?
Yes, it's in the courthouse.
right there? Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., State give you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both.
She is happy. She's happy. Sis, you going to jail, boo-boo. I tried to wait till trial and things like that, but sis, you going to jail, boo-boo. When I saw George Torres' mom and dad, that was so sad. Baby, you going to jail. You going to jail like your sis. Stop playing with these people.
This motion and also the motion to the statement of particulars formally and
Because she knows she's with the shit, so her rosacea is kicking in. My neighbor, my salty ass, if you guys remember me talking about my salty ass neighbor at the old house, baby, she had, when she would get mad, girl, that rosacea on her face, baby. You could read it all over her face.
writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery.
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th.
Let me tell you something. If I was the Florida bar, this guy would be on my list. I would be watching his ass. And it would be on some, nobody told you to respond to her ad. Like, were you coerced to respond to her ad? Is there any particular, do you have a Superman complex? Okay, so you thought you could come in, number one, disrupt what's already been disrupted for years now. You know she's a difficult client. You opted in. He would be on some, what's the guy's name? Melnick. Remember how Melnick got put on the bench for 6 months, can't practice law? This guy would regret the day that you filed the notice of appearance, okay? Fuck around if you want to. Fuck around, find out. You would regret the day that you entered that appearance dealing with this chick. So you better be ready to sit and handle the job at hand. Nobody told you to come in here. She was doing okay on her own. And now she's sitting there smirking like she thinks she done did something. And you know what? Let her find out. Let her find out. Because today I don't think it's going to go that great for her. She's going to be pissed.
And if hearings are necessary, we'll coordinate those.
And they're probably going to go pick up that laptop. All of her motions, they basically have thrown out. So anything that she has been afforded, now he said he was adopting Sarah's motions, but some of the privileges that she has been afforded as a pro se, watch, that computer is gone. Okay, computer gone. USB sticks gone. Everything is going to be returned back to either Prison Break or to the judge. Okay.
With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. You know, I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing defense. And there's a second doctor, Dr. Michael Brandon. I don't spell that right for me, sir. Dr. Michael Brandon. I don't know.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
Nobody cares. As it relates to Sarah.
This weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness.
Are they going to use the "That's my name, don't wear it out" defense? Because that's what I would like to know. Are they going to use the "Say it, don't spray it"? Are they going to use the "How do you play hide and go seek" when the only other person playing knows exactly where the other person is hiding and has them captive inside of a suitcase? How is so like, come on. Sir is really just trying to waste time.
So I'm gonna need an appointment for a forensic psychologist.
He's standing on he's standing on
Dr. Julie
a
Harper,
loser defense.
Dr. Mike
He's standing
Brandon,
on
and
business.
then the crime scene reconstructionist, Dr. Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case.
Look how happy she is.
Because of the claims that we're making, that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park, that was 4 years ago. The ownership of that apartment complex has changed hands, so it's
Not Judge problem to solve, not the people of Florida's problem, and certainly not the Torres family. And he should really be calling George Torres a victim.
going to be somewhat problematic.
Look at the judges looking like, if you don't shut your ass up and have several seats, sir. Wait, look at the clerk. Look at the clerk. Look at the clerk. The lady in the black jacket, and then Miss Barrios is over there like, I'm not saying a word because I know Judge is gonna be mad. Okay,
Trying to get it.
look at the clerk. Ah! The clerk is like, if you don't sit down and shut up, girl,
Information about who all the tenants were that they had witnessed some of
baby, her face is saying it all.
the
I
violence
know you
involved in
fucking
these two,
lying.
as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got.
Look at her off to the side. She is giving so much face today. I love it. Normally we don't even see his team is on point giving poker face. On today, she's like, baby, if you don't stop.
A lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams.
Do you see her? Girl, she is, I like Mr. What's her name? Mr. Sarah's new lawyer. All that stuff is on YouTube. We got it. Everything is already here on YouTube University. In the YouTube Law Library, it's already posted. All that body worn camera is posted. All those arrest reports, it's right here on the docket. If I can see it, you can see it. All you got to do is go to the portal and type in Boone and then Sarah. And I'm sure you have that real good access, so you probably can get everything. Sir, if we can see it on the YouTube streets, why are you bothering these people? It's all on the docket.
Body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome. That we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs since they've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Roberts.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. And it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement, that was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls.
This is my thing. You knew that this is a complicated case and that there were multi-layers to this woman's case when you decided to drag your ass into this situation. Not to mention, she put up that letter, I don't even know how long ago. I posted it on my community. The 28-page letter, was it 28 pages, girl? 50, the long ass letter that Sarah wrote and attached the ad to it for a lawyer. This is going back, was that June 28th? Okay. Over a month ago. They just had meetings a week or so ago, right? So she put up this letter over a month ago with the ad for a lawyer. You just decide to come on aboard. You already know that she's cuckoo. And you need all this time. You didn't know that the judge wasn't playing. How dare you on the strength of the state of Florida come through here and try to create another situation to cost the taxpayers more money. Like, to me, I feel like this is so irresponsible of him. If you want to come in and help the woman, that's your business, but you can't come through here and try to drag this out another year and make it seem like George Torres deserves to be wherever he is at this moment, not in the land of the living. Like, this is not his fault. The only thing that is his fault is that George probably should have left Sarah a long time ago, but George and Sarah were victims of each other. And unfortunately, George fell for the okie doke and is victim to Sarah and her manipulation, which cost him his life. But it is not his fault that he's dead. Like, he didn't ask Sarah to kill him.
Calls and ref reports and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Not me,
Okay.
my predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with this.
No, 1 trial cycle, 2 trial cycles, that's enough time for her to run you off. And for 2025 to be another year that he's trying to get this thing back on track. And the judge stated clearly in his 16-page motion when Patricia Cashman decided to exit that they are no longer paying for public defenders and that the trial is going to stay on track and on time. And if she decides to retain her own lawyer, that's her business. But at the end of the day, shit's gonna stay on track. And that's on period. That's what he said in his motion.
And
That's what the
for
judge
their
said.
opinions, I'm sure the state's going to want to take a deposition.
Look at the clerk. The clerk is like, stop it. Stop.
I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We've tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the sheriff.
She's had years to go through her discovery. She's had years.
Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, San Jose County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without better spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess
Do you know what the world's position is? This is that he's getting ready to give the state's position. I'm gonna give the world's position, or let me give the internet position. We don't give a fuck. That's I'm calling it for the YouTube streets. We don't give a fuck.
the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose any continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired. If the judge.
I'm going to call another thing too. Let me just say this for the streets. Let me say this on some keep your legs closed to married men and men out here who want to date women with husbands and are fugazi, because on the day that George died, when the police officer came, the husband said that they had been divorced for about 1.5 years. And she said when she was talking to the police officer that she had been dating George for 3.5 years. You guys do the math. Now, once again, it is not George's fault that he is deceased. He didn't ask Sarah Boone to take him out. I don't believe for 1 minute that he had any say in his ultimate demise, other than the fact that he really should have left her alone a long time ago. But that was his choice. He decided to be with her. But at the end of the day, you dating a married person, baby, it's not going to turn out well. Now, on top of that, what I'm also going to say is, don't you have to be a spouse to be a battered spouse? These two were not legally tied to each other. Either one of these two had free will to leave at any moment. They did not have children. They were not legally married. They actually had no contact orders. And really, one person had to be the person to get the fuck up and walk away. There was a police officer that was on body cam video who said, man, these things end in death. We're just trying to help you. You got to go. There's a court order. You can't be here. That officer, law enforcement came and separated them, and these two wanted to be together. Sarah cannot play both sides of the street. You opened up the door every single time. You went and bailed him out every single time. You sat up there and videotaped him, all of the things. There's just no fucks to be given on this defense. Nobody cares anymore. The only person we care about is the Torres family, who have to deal with the fact that their son was murdered. The lady was crying. So the mother, that he was a son, an uncle, a father. He was so many things to the family, and he's gone. But she said she was still grateful that she had him. She had him. And she got to experience him. The lady said she didn't even hate Sarah. But as far as that's the only people that deserve justice, George and his family. You can't, I mean, I'm trying to figure out how you're a battered spouse when you're not a spouse. Because if you were sitting up there as acknowledged as a girlfriend who time and time again, and you were of a melanin complexion, as someone said earlier, baby, they wouldn't even give you the privilege to call yourself a spouse, because you're not a spouse. How are you getting battered spouse, battered partner? I don't know what you call it. But how is she getting battered spouse when her and George were not even married?
Doesn't continue today. He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she needs the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
It was so sad, 504. It really was.
All right, thank you very much. All right, Mr. Oaks, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. Um, This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th. 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed.
Okay, the judge is red. He's pissed. It's rosacea in the house. Everybody's rosacea is flaring up. Everybody's blood pressure is evident. Sir is pulling out his legal pad. He's got his order pulled up. He is like, okay, what? Okay. Yeah. This is
With regard to
getting
Mr. Heller.
juicy.
Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were
So basically what I'm hearing the judge say is we've paid for resources. Those stones have been turned. That evidence, that information should already have been collected by her host of attorneys and all of the shenanigans of the past 4 years. Go get in her box. Go get her box. Go down to the jail and ask Captain DiGiovanni for the box of evidence. Call the other attorneys and ask them who you need to talk to, and you better get on the horn and get all the people in your office, because I smell. How long do you guys think is this guy? Maybe we should put up a poll. Is Mr. Owens going to make it to trial? Is he going to? I don't even feel like it's a yes or no. How long does Owens last? Is he going to get to trial? Is he going to be gone in trial? Supposed to start on 10/7. Will he make it 1 week? Well, he's already made it a week. Okay, let's give him 3 weeks. I don't know why I'm saying 3, but he already made it last week. Hold on. He said he talked to her on the 20th. I have to look at the document. This could be his 3rd week. I have to look when he did his notice of appearance, but he said something about that he had met with her on several days. So let's just say he's into his 2nd week, to be fair. Is he going to make it past this week? So that'll be 3 weeks. Will he make it 5 weeks? Will he make it to trial? Will he make it to verdict? That's going to be 3, 5, trial, verdict. What do you guys think? Because 5 weeks from now, really 5 weeks is kind of a moot point, because 1, 2, 3, 4, 5 weeks. He can't quit during the trial. So the trial starts on the 7th. So is he going to make it? This could be his third, fourth, 5. Okay, let's say, does he make it 3 weeks? Does he make it 5 weeks? Does he make it to trial? Does he make it to verdict? I don't think he could quit during the trial. I don't even know if that's possible. Give him till Friday. Wow. Because the judge is nice, but he's like, don't get it twisted. Don't get it twisted.
Also,
You say
Dr.
3 more weeks, so he's
Jorge,
going to make it to
2
trial,
times,
huh?
sought to be appointed, once by Attorney Bankowitz. Dr. Jury specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again, by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State, 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the Florida 4th DCA 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days.
16 continuances, 4 years, 6 months, and 16 days. Bitch, have a seat. Have a seat. Have several seats, guys. Look, will Sarah's lawyer make it? Will Sarah's lawyer make it? 384 of you in the mist. No, give him to the end of the week. 2 more weeks. He will make it to trial. He will make it to verdict. Okay. If he makes it to trial, he'll probably make it to verdict unless he wants to lose his law license. I think everybody in the world is going to be calling the Florida bar if this guy exits. Like, sir, you never should have been here. This is you really, your wife must have a good job, sir. Sir, Mr. Owens, you're not doing this for pay. You came here on your own. You understood the assignment. Isn't that what the judge said? He said you understood the assignment, sir. Baby, I hope your wife has a good job. Okay.
On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation and trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motion.
It looks like she's understanding. You know how she like, Judge, I guess I'm just not understanding because I'm not prepared. I wasn't informed, and da 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 da. It looks like she's understanding right now. Doesn't it seem like she's understand? You know how they'll say, like, I don't understand. Can you repeat that again? Sir, can you? I'm not sure. Yeah, where's your smirk now? You're not smiling at your attorney now. Oh, okay. She thought she was going to come in there. I would love to see the inmate notes on today. Ooh, I bet you those inmate notes are a fool. Okay.
For attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15th.
Wait a second. So when he entered, they went ahead and researched him. Are you hearing this? The judge said you were not court appointed, but we went ahead and looked into you, sir. Baby. Ooh.
Allen, Padilla, Bankwoods, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15th, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the matter of spousal syndrome of defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state 311, 7, 3rd, 185, and 10.189, Florida 2nd DCA 2020, your motion for continuance is denied. Matter of this trial is still set for October.
Boom. Okay, I'm gonna have to. Is PW here? You guys already know, girl. I'm gonna do one more time. A mess. A whole mess. Sir. He just dragged him. I didn't see it coming. Did you guys even see it coming? The judge basically, he pulled his little notepad out. Baby, he dragged him. He dragged him unexpectedly. It was the unexpected drag for me from the judge. I was like, wait a second. Okay. Baby, that was a drag followed up with motion denied. Okay. Girl. Okay, let's finish this up because this was good. Okay. There are no problems.
The 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients. Okay, I've got other people covered, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear my Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. You know, I went to the jail yesterday.
His name is James Owens. I introduced him to you guys last week when he filed his appearance, his notice of appearance. So if you go back to the last Sarah Boone video, we talked about it. It's the one where we talked about Sheriff Labatt. So that's the thumbnail. It's Sheriff Labatt and Sarah Boone on the thumbnail. And yeah, we went to his website and looked at and kind of got a little bit of information. We did our own due diligence. Okay. So yes, go to that one and then check him out, because it's giving, he thought that Sarah was going to get some privileges, and it's giving she's already used them all up.
I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what I assume is being redacted. I know some of the audio in terms of clients' comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuous again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
I'm going to say no. What do you guys say? Let's just say no. We're going to just say no to everything. It's October, whatever, and you better stay on time, sir.
Give me a moment. On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lang was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive which contains the state's digital evidence. tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m., a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, the pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go buy jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it.
All of this is not his problem. Like, why is it so hard for people to give an answer? Just if you give an answer, then he might say, I need you to qualify why it's going to take you so long. Then you give all that extra. Nobody gives a fuck that you're getting on a flight. Nobody cares.
It done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
Give me 1 minute.
Sure.
That's
State, anything else?
not this time, Your Honor.
Madam Clerk is going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no other business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Damn, I wish we could have. Did he give her a fist bump? He gave her a fist bump with her shackles. Not a fist bump. Is that appropriate, sir? Mm-mm-mm. He had the nerve to call George Torres, the late deceased victim of the spousal battery. Torres. He gave the man no respect. I'm telling you, this particular this is Orange County, baby. I don't know about Milton, Florida, but we've spent a lot of time in Orlando. And Orlando, you better watch it. You better watch it. Okay. You just calling Mr. Torres like that. You don't know who the makeup of this jury is going to be. And they better put some respect on Mr. Torres's name because he's a victim. If he wasn't a victim, she wouldn't be in jail for the past 4 years, damn 6 months and 16 days awaiting trial on second-degree murder. That sounds like there was a victim. If there's a second-degree murder being tried, there's a victim, right? Mm. I don't like him either. I don't like him either. I feel like he's a little bit loose with his mouth on and better put some respect on Mr. Torres's name because his family is going to be there and he deserves that he deserves that. The man was a victim of a heinous crime and died a miserable death in his last 24 hours. He died a death nobody wants. Okay? Sarah is happy. Look at that. You see her body language? You see how she like first of all, so it's the shackles for me. So she gets up, she has the body chain around her waist and she has her handcuffs and the security guard or security officer has the shackles in her hand with gloves on. She put her hand on Sarah's shoulder, I guess to get a firm grip. She lets her out the box. She puts her hand on the shoulder, kind of like, you wait. Okay, now she has her leash or her shackles. And Sarah does a over the shoulder bye. Look at that. Bye. See you later. Let me screenshot that. Maybe that'll be my thumbnail. Bye, Sarah. Okay. A mess. This is a certified mess. Okay, bye, Sarah. Interesting. Y'all, we can only hope that Ernesto's is going to act as much foolishness is. Do you think Nesto is going to give in court? PW, did you hear us earlier? Girl, we had to. When the judge said no, the judge said no. You might have got here just a few minutes ago, but we've been here, and the answer is no. We are not waiting anymore. This show is in progress. Okay. Okay. All right, guys. That's it. That's all. That was interesting, right? Let's get the vote. We have 358. Gosh, only 162 of you guys have voted. But the likes are up. So thank you. The likes are liking and thank you very much. Can you guys look at your phones for a second? Make sure you are subscribed to this channel, please. Make sure and that your notifications are set to all so that you can always be notified every time I go live, post a video and do all of the things. And hit the thumbs up. Okay. Why don't you? It's a free way to support the channel. All of those things were free. Subscribing, notifications, and hitting the like. All of that is totally free. Thank you. And furthermore, voting. My God. Okay. All right, guys, let's finalize this vote. Will Sarah's lawyer make it? 41% of you guys, baby. Let's start from the bottom. 168 votes. Will Sarah's lawyer make it? 9% of you say that he will make it to verdict. 17% of you say he will make it to trial. Maybe something drastic is going to happen. 30% give him 2 more weeks. And 41% of you, girl, I don't think it's going to make dollars or cents. And when he finds out JAC is not giving him a dime, baby, I think he's going to run for the hills. Maybe he thought he was going to get some of that JAC money, but maybe he is public defender certified. I don't know. But the judge added to the record that he was not court appointed and that he accepted this assignment on his free will. And that sounds like, let the record show you're not getting paid, sir. That's what I think is going to happen. They're not cutting you a check. So now he's going to have to catch flights. He's going to be paying for things on his own dime. And he's doing this pro bono. Because it was never said Sarah couldn't have a lawyer. It was just said Florida's not paying for it anymore. Okay. Florida said, no. Florida said, we're done. We're done paying for you, Sarah. Sarah. Okay. Where is my Sarah cover lay? Did I take Sarah off of here? I think maybe I took her off. I had some. Oh, well. Okay. Anywho, I guess I don't know where it is. I guess I took it off of here. Anyhow, okay. Well, Sarah. Girl. Anyway, okay. We will finish up. It's pro bono. It is pro bono. Glorious, is today your birthday? I feel like, did you say Tuesday was your birthday? Guys, it's Glorious Love's birthday season. Glorious Love is a Virgo like me. Yes. Okay, all the Virgos in the house, stand up. It's Virgo season. All of the August birthdays, Leos and Virgos, I hope you guys enjoyed, but it's September now. And Virgo season runs all year, in case you did not know. Virgo season runs all year, and happy birthday to all my Virgos out there. Yes, 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 yes. It's our time. I feel like it takes forever for Virgo season to really like legit kick off. And I know it makes people mad that we drag it out all year, but that's just the joy and the fun of loving on a Virgo. Okay. If you love a Virgo, then you get it. And ain't nothing stopping it. Okay. Baby. That's just the way it works. Okay. Yes. All the Virgo love out here. Soak it in. Yes. Okay. Yes, September 17th. Glorious Love, today is your birthday. Is today your birthday, sis? You say you're confused. Don't be confused. 504. 504. 5 plus 0 plus 4 equals 9. And 9 is what? It's the 9th month. It's September. And that's Virgo season. 504. Yes, 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 yes. You like how I put that together? Girl. 504 equals 9, which equals September, which equals my favorite number. That's my lucky number. And the number of my favorite month, which equals September. Yay! Exo Love, what? You heard me. 504 is always period. Period. Okay. Yes. Okay, guys, this was fun. I really enjoyed a different type of lunch. We had something different on the menu today, but we will come back with some Nesto. What time is it? 1:40? Baby, I don't have the energy. Yeah, I'm going to take myself a nice little break. I do have something booster related. Yesterday was your 60th. Miss C60 Virgo, baby, happy birthday, sis. Happy birthday. Blue sapphire is probably, I'm sure, yes, I was going to say probably a Virgo because sapphires, that's our stone. blue sapphires, as if there's any other sapphire you should love. Sapphires are amazing. Did someone mention, no, we don't, I mean, Sonia is having a birthday, but so is, there's a, you know what I'm saying? Like, it's okay. We don't have to bring her up. In happy times, we just run the shits with her, with old Sonia. Sonia doesn't get our time. Okay, guys, happy birthday to all of the beautiful ladies of Bougie Gang. Thank you so much for joining. I enjoyed lunch. Thank you for joining us. And this was such a fun time. And I enjoyed having a little something different for lunch. We will resume and finish up this call. I promise. I have a meeting. I don't know how long it's going to last, maybe about 30 minutes. But yeah, let me go check and see what I got to do for dinner. And based on that, then I'll know a little bit better what time I'll be back. But we're definitely going to finish up that call because I feel like there's more coming. Someone asked me, maybe Vicky, if you're still here, boo. Somebody asked me about July and the visitors report. I did just get a visitors report. I should try to scan it in. Well, you know what? I will make it a post on, where can I put this? Does this have personal information on it? I'll put it on Instagram. I'll put it on my Instagram. But as far as July is concerned, July 8th, visit by Sonia. July 15th, visit by Sonia. July 23rd, visit by Sonia. We may have already seen all of these videos because we haven't seen like a ton of video visits. July 30th and August 11th. Since August 11th, I guess I need to make another request. That request took so long to damn get here. It was ridiculous, but I'm not going to complain because the girls from the office might even be listening. So it's no tea, no shade. I'm not sure what happened. It could have been someone was on vacation, whatever, but no Bible lady. That's the news. So someone asked me, had Bible lady been to see Ernesto? And as far as I know, I need to look at my last visitation report. But as far as July is concerned, and I'm talking about July 8th through the month ending in August 11th, no Bible lady visits. Sis has been oh so busy on these on the YSL streets. So just to let you all know about that. But I'll cross-reference and see where my last one left off and see. But as far as period, yeah, no, Bible lady hadn't been there in a minute. And I'm talking about Bible lady YouTube streets, Bible lady, not Bible lady from the comment section. Bible lady from the comment section is not the Bible lady of which I am referencing. She's been busy panhandling. Well, on some broke as a joke, which I don't know that for facts. I have no idea. She's too busy throwing her raisins to. Y'all need to stop it right now. Let me drop my banner. Okay. Girl, this commentary is for criticism, entertainment, and teaching purposes because we got to let a bitch know. I'm just kidding. Let me stop it. All commentary is based on the video and opinions, mine, yours, and anybody else's. Any allegations and shenanigans are alleged. What does Tasha K say? It's all allegedly, unless specified by the source media or materials, past, present, or future. Anyone accused of a criminal allegation has a right to due process and is considered innocent until proven guilty, including your hostess with the mostess. Okay. And that's on some hashtag fair use. Okay. That's on some hashtag Copyright Act of 1975. And that's on standing on Bougie Gang. Okay. Period. All right. Anywho, you guys have a wonderful day. I'm gonna go handle some business. And I will see you guys next time I go live, post a video, do all of the things. If you guys want me to come back and finish up the reaction from yesterday that we ended up talking to Joey for like 2 hours, let me know. Run up the likes for me. Let me know down in the comments. Let's finish up what we started, because I feel like the call that went with this one, the same thing happened. Joey, do you have something against Dre calls? That's what I want to know. The sister call to the call that we did not finish yesterday, the exact same thing happened. Can I take you guys back in history? The day that we were doing the reaction to the call when Nesto called Dre mad as hell, Joey called in that day and we didn't get the reaction done. It's just a little bit of conspiracy corner. I don't know. Maybe Joey from the comments has a thing with Joey calls. We're going to have to ask Joey next time. We're going to have to ask him, sir, do you have a problem when Dre shows up to the YouTube streets? Because even though Dre wasn't on the call, it was it's not a coincidence that that call that Nesto is referring to, when he talked to Dre back to back for an hour, we started reacting to that call and Joey called in that day and we never got to finish that one either. Is that weird? Do you think Joey has some relation to Dre? Is that what's going on? Let me just throw some more conspiracies out here. Joey is a court recorder. Ooh. Joey is a Dre disruptor. Really? Let me stop. Joey, come clear the suspicions. Y'all better leave Joey alone. I know. That's our good friend, though. That's our good friend. He is a friend to the show, and he's also he's damn near a contributor. So thank you so, Joey. We love you out here. Thank you so much for all you do and supporting and bringing us all your good perspective and TT. We're just joking on a Tuesday that feels like a Monday. Okay. All right, guys. You guys have a wonderful afternoon. I will see you guys later. Okay. Joey, just be long-winded. Yes. Me too. You guys don't like, let me just say one other thing. You guys don't like when I interrupt Joey. When Joey is giving a point, if I even interrupt a little bit, there's always someone to come in the comments that says, I don't let him speak. And it's like, bye. That's not true. It's a conversation. It's not a takeover. It's a conversation, right? Anyway, okay, I'm going to let y'all go like a good secretary. I got to go. You guys have a wonderful afternoon. Be blessed, not stressed. It's Virgo season. Make sure you let a Virgo know today how much you love them off of me. You let a Virgo know today how special they are to you. Okay, it's Virgo appreciation out here. August lady, I appreciate you. We love you. Glorious love, Miss C, all of my Virgos. Happy birthday off of me. Okay, August lady, B Williams, all of you. Wait, what did let me see. I missed it. I was just about to click on a comment. Was that Miss HLS? Hold on. I'm here for Fran. Oh, you're so sweet. Thank you. She's here for me. We're celebrating all December for me. Okay, 504. We love you. I'm a Virgo rising, so I'm celebrating with y'all. Okay, period. Absolutely. All right, guys, take care. Have a good afternoon, and we will do this thing again a little bit later.
But me, I just dogged on all the way around. Nasty Nesto. I'm I'm telling folks, man, I ain't did nothing with these folks, man. Hold on, no.
What's your name, Miss Silver?
They call me
What's your name, Miss Silver?
They call me
You know what? You know what?
What?
It's funny that you said that you just brought back some memories. So when you said that, when I told you, I think I took a phone call back. Remember I told you, I said, you know what they call you right here? Yeah, you say what? And I said they call you Nasty Nesto, right? How I said. So they don't took my voice.
I can speak to that. As to 23 CP 215407 at our last hearing, the state did move to null process or to decline that particular case. We will just revive that case in an indictment.
What's your name, Miss Silver?
They call me Nasty.
We will just revive that case in an indictment. We'll just revive that in indictment.
Nesto or some shit I ain't do.
You know what?